Once again, I'd like to welcome everyone to our webinar, Research in HIPAA, Recruitment, Consent, and Beyond. We're excited to be discussing this topic with you today. I'm Ari Burgess, Quorum's Director of Client Relations, and due to high demand, this is our second of 2 webinars on this topic. Additionally, if this is the first of many informative webinars that we'll plan on hosting in 2012. On that note, if you'd like to stay informed on Quorum initiatives, such as our webinars, be sure to sign up for our mailing list. You can find the mail list by going to our website, quorumreview.com, and clicking on the News and Events section. The mail list sign-up is in the upper right corner. This will ensure that you'll receive the latest e-news updates from Quorum, which includes Quorum's responses to FDA guidance, trends in clinical trial review, and our quarterly e-news publication, the Quorum Forum. Immediately following this webinar, we invite you to participate in a brief survey that will help us know what type of topics interest you. This allows us to continue to offer webinars that are current and informative. So at the end of this webinar, please do take a few moments to complete this survey. I'll be giving you a brief overview of Quorum before I introduce our presenter. But first off, I'd like to cover a few housekeeping items. Questions and answers. Feel free to submit questions at any point during the webinar using the chat box on your webinar dashboard. If time allows, we're going to answer a few of these questions at the end of the webinar. The remaining Q&A will be posted on our website, and we'll let you know when those are available through a link that we'll be emailing to you. The recording and slide deck. The webinar slide deck and the recording will be posted on our website. The slide deck should be available within 24 hours of the conclusion of this webinar, and the recording should be available on our website within 5 business days. We'll be emailing you a link to both of these as soon as they become available. Feel free to share this link with your staff and or your colleagues at any point in time. And now a few words about Quorum Review IRB. Quorum Review IRB is an accredited IRB. We're fully accredited with the Association for Accreditation of Human Research Protection Programs, AHRP, through 2014. We're also fully compliant with the FDA and OHRP requirements. Quorum has international capabilities in that we have boards available for the review of both U.S. and Canadian studies. Quorum has a very strong framework. Quorum has approximately 150 employees, which makes us one of the largest IRBs in the United States. Quorum is also very proud of our certified IRB professional certification individuals. More than 60% of our affiliated IRB members, 40% of our regulatory staff, and 20% of study management and study support positions all hold the CIP. Quorum offers 13 board meetings each week. Our site turnaround times are among the best in the industry, with 24-hour site turnaround, 36-hour amendment review, and same-day site changes, all of being available. Quorum also tries to minimize the amount of redundant information that you have to send us, so you only need to send us your CV once and audit documentation once unless it changes, and we will then request you submit updated information to us. Quorum has customer support available from 8 a.m. to 8 p.m. Eastern Standard Time. Every study that comes through Quorum will receive a dedicated study manager that will attend those studies with those studies the IRB meetings, and then we'll communicate the results back to you. Quorum also offers a secure portal with smart forms, status reports, and approval documents all being available within its portal. We offer a customized phase 1 and post-marketing processes. We're aware that those are different processes and require different types of things from an IRB. Quorum also works very closely with many academic medical centers. We have a flexible and customized process available for these academic medical centers. And we know that quality control is super important to you guys, so we offer 100% quality control on all of our documents. And now I'd like to introduce our presenter. Our presenter for today's webinar is Claire Carberry. Claire joined Quorum Review in September of 2009 as a regulatory attorney. Prior to joining Quorum Review's regulatory department, Ms. Carberry worked as a regulatory analyst and legal intern at Western IRB. Ms. Carberry passed the certified IRB professional exam and has held her CIP certification since 2010. She currently serves as a member of the Northwest Association for Biomedical Research, or NAWABR, and Public Responsibility in Medicine and Research, or PRIMER. Ms. Carberry received her Juris Doctor from Seattle University in 2007 and was admitted to the Washington State Bar Association in the fall of 2007. In addition, Ms. Carberry is a member of the Health and Corporate Law sections of the WSBA. And now I'm going to pass the slides over to Claire.
Okay, thank you, Ari. Can you hear me? I'm glad to have all of you here with us today. This is obviously a topic that many of you would like more information about because we've had a great response. So I'm hoping that this information will be helpful. Before we get started, I do want to give the disclaimer that this information is intended to be a general overview and that you should always be consulting with the appropriate legal department or compliance group at your organization when you have a specific question about HIPAA and the privacy rule and how it might apply in a certain situation. Here's an overview of what we'll be covering today during the presentation. First, I'll be briefly touching on the history of HIPAA and some definitions. Then I'll review HIPAA identifiers, and then we'll get into the meat of the presentation. I'll be discussing some considerations with respect to HIPAA prior to beginning research. I'll be going through the requirements of an authorization. I'll discuss the types of research where an authorization is not needed, and then I'll cover things that can come up both during the course of the research and after study closure. After that, we'll walk through a couple of examples to test our knowledge. Okay, getting started here with our introduction. I have a brief slide here to get us grounded. The Health Insurance Portability and Accountability Act, or HIPAA, was passed in 1996. The privacy rule is a federal regulation that was issued by the Department of Health and Human Services in 2000. And that was promulgated to carry out HIPAA's mandate that HHS establish federal standards for safeguarding the privacy of individually identifiable health information. So the privacy rule is what regulates the way that covered entities handle individually identifiable information known as protected health information, or PHI. We'll define those terms in the next couple of slides here. The rule establishes the conditions under which covered entities can use or disclose PHI, including in the context of research, so both in the context of providing care and also in research. Okay, I've included several definitions on this slide in the next couple of slides, and I'm not going to go through all of them word for word, but I want you to have them if you're referring back to these slides down the line. So the first definition here is a covered entity, which I mentioned earlier. And for the purposes of this presentation, I won't be going into an analysis of how you determine whether you are a covered entity. That's a topic for another presentation. So moving forward, we're going to assume that we're dealing with covered entities when I'm talking about particular scenarios and applying the privacy rule restrictions. Moving on, I've included the definitions here of health information, which you can read, and then individually identifiable health information, which you'll note is a subset of health information. That includes demographic information. You'll see this as essentially health information that either identifies the individual or that there is a reasonable basis to believe the information could be used to identify an individual. Okay, moving to the next slide. We have the definition of protected health information, or PHI, which is a subset of that individually identifiable health information that is transmitted or maintained in electronic media or transmitted or maintained in any other form or medium. Then we have the definition of an authorization, and we'll get into this concept in a lot more detail later on in the presentation. Essentially, an authorization is an individual's agreement to use and disclose their PHI, and it's generally given when an individual signs an authorization that describes uses and disclosures that would otherwise not be permitted under the rule without that authorization in place. And I just want to point out that when we're talking about this in the context of research, the authorization is an additional requirement beyond the requirement for informed consent under the HHS and FDA rules. Another definition here on this slide is a business associate. It's not something I'm going to be discussing in the context of this presentation, but there is the definition for your reference there. Okay, Another definition here is a privacy board. And a privacy board is an alternative review board that's authorized by the privacy rule to review requests for alterations or waivers of a research authorization. And we'll be discussing authorizations and waivers also later on in this presentation. So the board, the privacy board, needs to be established in accordance with restrictions under the privacy rule, which requires the following to be in place. The members have to have varying backgrounds and appropriate professional competencies in order to review the effect of the research protocol on individual privacy rights and related interests. Each board member must have at least one member who is not affiliated with the covered entity or with any entity that's conducting or sponsoring the research, and also they cannot be related to any person who is affiliated with these entities. And lastly, members cannot have a conflict of interest regarding the projects they review. Now, I want to point out here that a privacy board is an option, but an IRB can also review anything that a privacy board could review. So they're interchangeable in that way. And lastly, a designated record set. And again, this will come up later, so I'm defining it here now that we have that. So we have that for reference. It's a group of records that are maintained by or for a covered entity that includes certain types of information and is used to make decisions about the patient. Research records that are maintained by a covered entity could be part of a designated record set if the records are medically related or used to make decisions about the participant. And this will come up later when we discuss subjects' access to their research records. Another basic concept we need to be familiar with before we move into the next part of this discussion is HIPAA identifiers. So here's a list of the different types of information that, according to the privacy rule, when that information is not available in connection with other data, the remaining data is de-identified. But if this data is available, the information is considered identifiable. So that's for purposes of HIPAA compliance, and I know that there's lots of opinions out there as to whether or not something really is identifiable, well, whether something really is unidentifiable in the absence of these types of information, because there's other things that potentially could identify the information. But for HIPAA purposes, these are the identifiers that we're dealing with. Now, two things I want to call attention to on this list are, first, dates. Note that all elements of dates except for the year that are directly related to an individual are considered an identifier. And this includes dates that are related to medical treatment. And that's something that we often see people not realizing when we see certain types of submissions. So that's important to keep in mind. And the second important identifier is the last on this list. And that's any other unique identifying number, characteristic, or code. And that is a really important catch-all that can sometimes hang people up as well. So to the extent that there are numbers that are unique to an individual's information, they're considered an identifier. Okay, so now we've gotten through some basics related to HIPAA and the privacy rule, and I'd like to move into HIPAA before the research begins. So before I jump into this discussion, what I'm going to be talking about here before the research begins is more formal types of recruitment activities. And I want to note that the privacy rule generally permits a covered entity to communicate with an individual and disclose their own PHI to them. So if a discussion of a particular trial is coming up organically in the context of a visit between the physician and the patient, perhaps the physician is discussing treatment options and suggests the possibility of a trial with the patient, there are not restrictions on that type of conversation. What I'll be discussing here in the next couple of slides is in the context of seeking out subjects in a more formal way, and when you're not just relying on that discussion to come up between the doctor and a patient. So first I'm going to talk about activities that are preparatory to research. So for activities involved in preparing research, covered entities can use or disclose PHI to a researcher without an individual's authorization. So the person does not have to provide their permission through an authorization if the PI makes certain representations. And those representations are listed here. The first is the use and disclosure of the PHI is only for activities that are preparatory to research. The second, and those are on the same bullet there, so that second sentence should be a second prong there. No PHI will be removed from the covered entity during the review. And then the third is the PHI is necessary for research purposes. So those representations need to be made, and in that circumstance that those representations are made, it's possible, it's allowed that the covered entity use and disclose PHI to a researcher without an authorization. The preparatory to research provision also allows researchers to contact individuals in two circumstances. So there's, and this is another level. So initially what I was talking about here is just the use and disclosure of PHI, and now what I'm talking about is actually contacting individuals. So if the researcher works for the covered entity and is contacting the individual for the purpose of seeking authorization, that is an allowable activity under the privacy rule. And then also, if the covered entity has obtained documentation that an IRB or a privacy board has partially waived authorization requirements, they can disclose to the researcher certain PHI that's necessary for the researcher to contact the individual. Okay, moving on. The privacy rule allows researchers to seek a partial waiver of authorization for recruitment from an IRB or privacy board. And the waiver is considered partial because the requirement to obtain an authorization is still in place for all other research purposes. So a partial waiver can be granted when certain waiver criteria are met, which I will discuss further on in this presentation. I also included a bullet because I want to talk about advertising just briefly here. How we advertise online today, it's possible that that could implicate HIPAA or the privacy rule because of the types of targeted advertising that happens. So to the extent that we're advertising to an individual based on their search history or email content or other online activity, it is possible that there could be implications under HIPAA, and it's certainly something we want to keep in mind. And finally, recruitment databases. It's certainly something that can be developed, and it's acceptable to put individual PHI into a recruitment database generally if you obtain an authorization from the individual. So the authorization would need to inform individuals about the purpose of the database, how their information is going to be used and disclosed, and explain to them that the purpose is for screening them for various clinical trials. Okay, so once we've identified potential subjects, screening begins, and there's a couple of issues that come up routinely that we see here at Quorum in the context of screening that implicate the privacy rule and can be confusing to people. So first, screening logs. When a researcher has identified a subject, and that may be by looking at their records, and then either by review of the record or contact with the patient, they develop a log of patients that are screen failures. If the log contains identifiers, a partial waiver might be needed. And so it's important to think of how screen failures are going to be documented and to get that partial waiver of authorization if you'll need it based on the information that you're recording. And then the next bullet here is phone scripts. If you're using a call center, the call center employee that's answering the phone can tell individuals about a study. So say they're responding to an ad and calling in, but as soon as they're using and disclosing PHI, the privacy rule is implicated. So a best practice is at the outset of that conversation to obtain verbal authorization over the phone prior to requesting and collecting the individual's PHI. And this can be done through requesting an alteration of the authorization requirement for a signature. We'll talk a little bit more about that later on in the presentation. And then the script that's read or the authorization that's read should still include all of the elements that are required to be in an authorization unless any of those are also waived by an IRB or privacy board. Okay, so now I've covered the privacy rule in the context of recruitment and screening, and I'm going to move into the privacy rule as research begins. The privacy rule permits a covered entity to use or disclose PHI for research in several situations, which I've listed here. First, when the individual provides an authorization signed by an individual, which I'll discuss on our next slide here. Also, in the case of reviews preparatory to research, which I just discussed earlier, and the rest of the scenarios I'm going to talk about further on in the presentation, research on information of deceased individuals, when an IRB or privacy board grants a waiver of authorization, if the PHI has been de-identified in accordance with standards that are set forth in the privacy rule, when you're working with something that's called a limited data set. And the last option that I'm not going to go into depth about today, but that is an option here, is under a grandfathered informed consent or an IRB waiver of authorization to use and disclose information for research under transition provisions of the privacy rule. And that was when the privacy rule was first being implemented. All right, so we've talked about an authorization. I've referenced it a couple of times already. Digging into that a little bit more, as I mentioned earlier, an authorization is an individual's signed permission that allows a covered entity to use or disclose the individual's PHI for the purposes of the research and to the recipients that are stated in the authorization. And this is required for a covered entity to use or disclose an individual's information for research purposes, except in certain exceptions, which we discussed on the last slide. I also want to note that an authorization can be blended into the informed consent, and it's possible to eliminate duplicative language in certain circumstances that might cover both requirements under the authorization requirements and informed consent requirements relating to privacy. Okay, so the privacy rule outlines what an authorization needs to include, and there are several core elements and there are also required statements, and this slide here lists all of the core elements. So the first bullet here is a description of the PHI to be used or disclosed, and it needs to identify the information in a specific and meaningful manner, and that is important. That specific and meaningful manner requirement is important when we talk about the use and disclosure and whether something may or may not be covered under an authorization when you may want to make changes to the research down the line. The next two bullets here indicate that the authorization must identify individuals authorized to make the use or disclosure, and also it must identify the individuals or organizations to whom the use or disclosure will be made. The authorization also needs to include a description of each purpose of the requested use or disclosure. It also needs to include an expiration date or an expiration event that relates to the individual or to the purpose of the use or disclosure. So the end of the research study or none. But I would note here that certain states require a specific end date, and it's also possible that your organization might have some requirements around what type of expiration needs to be listed. So it's important to pay attention to your local law and also to your own organizational requirements. And finally, the signature and the date of the individual are a core element of an authorization, or it is one of the core elements. Okay, and then there are also required statements that need to be included in the authorization. So the first is a statement indicating the individual can revoke their authorization and how to do so, and if applicable, the exceptions to the right to revoke their authorization. The authorization needs to explain whether treatment, payment, enrollment, or eligibility of benefits could be conditioned on the authorization, including research-related treatment, and what the consequences are of refusing to sign the authorization if applicable. So typically what we see in the context of research is that if the individual does not want to authorize the use and disclosure of their information, they're not allowed to participate in the research. And lastly, a statement of the potential risk that PHI will be redisclosed by the recipient. And this may be a general statement that the privacy rule won't protect the information after it's been disclosed to certain recipients if they're not covered entities. Okay, so I'm going to talk here a little bit about authorizations and a standalone authorization versus one that's blended into the consent form and the requirements around IRB review in those circumstances. So the FDA regulations do not require IRBs to review and approve a standalone authorization, but they do require them to adopt and follow written procedures for reviewing clinical research. So to the extent that an IRB does have a written procedure that requires them to review and approve all written materials that are provided to research subjects, then they would have to review a standalone authorization. As far as pros and cons of a standalone versus a blended informed consent and authorization, the biggest pro of a blended consent form and authorization is that you minimize the number of documents that you're managing, but I don't know that that necessarily means a combined form is easier to manage. I think there's differences of opinion on that. The standalone authorization does have the advantage that it helps to keep clear the difference between consenting to the research and authorizing the use and disclosure of the individual's information. Ultimately, the decision of whether to blend an authorization into the consent form or keep it separate is up to the site where the research is being conducted. So researchers need to be aware of their organizational policies surrounding this issue. Okay, so now we've reached a discussion of alterations and waivers, which you've heard me make reference to in the context of partial waiver for recruitment. If we're thinking back to that partial waiver piece, the standards that I'm going to discuss here on this slide also apply to the partial waiver. So the IRB or privacy board that's reviewing a request for a partial waiver for recruitment purposes has to apply this same test as they would if there were a request for a complete waiver request for a research protocol. So the standard is there's three categories here, and the first has some subsections. The use and disclosure of PHI needs to involve no more than minimal risk, and this is what the IRB is evaluating or the privacy board is evaluating. So this is their first determination that they need to make. No more than minimal risk to the privacy of individuals based on at least the presence of the following elements. So there needs to be an adequate plan to protect the information. There needs to be an adequate plan to destroy identifiers at the earliest opportunity, and there need to be adequate written assurances that the PHI will not be reused or disclosed to any other person or entity except as required by law or for an authorized oversight of the study or other research purposes which would be permitted under the privacy rule without an authorization. 2, the IRB or privacy board needs to determine that the research could not be practically conducted without the waiver or alteration. And 3, they need to determine that the research could not be practically conducted without access to and use of the PHI. So the privacy rule does allow a covered entity to rely on a waiver or alteration of authorization that's approved by any IRB or privacy board. So it's possible to get a waiver or an alteration granted by an IRB or privacy board anywhere, and that could apply to the research taking place at multiple locations. But it's important to keep in mind that your particular organization where the research is being conducted may have a policy that they require review of an alteration or waiver request themselves at their own IRB or privacy board. So certainly you should be providing information about whether an IRB or privacy board has granted or not a request, but it may be that you also have to obtain an additional review depending on what the policies are at a given site. Okay, so now that we've covered authorizations and the circumstances in which you can obtain a waiver or an alteration, I'll cover some situations when an authorization is not required. And this includes research involving decedents' records, research involving de-identified data, and then also research involving limited data sets. So first we have decedent's records, and a covered entity can provide access to decedent's records for research purposes if they receive some representations from the researcher. So the first is that the use or disclosure is sought solely for research on the PHI of decedents, and the second is that the PHI for which the use or disclosure is sought is necessary for research purposes. Now, a covered entity can request documentation of the death of individuals whose PHI is sought by researchers, in addition to requiring these representations from the researcher. However, I want to note here that if these conditions are met, that you don't need an authorization, nor do you need an alteration or a waiver of authorization to be approved by an IRB or privacy board to conduct research on using decedent information. So the next slide is about research involving de-identified data. And there aren't any restrictions under HIPAA on the use of and disclosure of de-identified information because it's not technically PHI, so it doesn't fall under the privacy rule at all. There's two ways to de-identify data. So the first is the safe harbor method is what it's called. You can see there in quotes, and that's to remove all 18 identifiers that are outlined in the privacy rule if we think back to our slide with the identifiers. And there's also a requirement that the covered entity cannot have actual knowledge that it would be possible to use the remaining information either alone or in combination with other information to identify the individual. So even if those identifiers have been removed, if they know that somehow there could be a connection made, then it's not considered de-identified. And the second option is to have a qualified statistician make a determination using particular statistical and scientific methods that the risk is very small that the information could be used either alone in combination or in combination with other reasonably available information by the recipient to identify the subject. And the methods and the results of their analysis need to be documented as well. Okay, and our last scenario here where an authorization is not required is research involving a limited data set. So that refers to PHI that excludes 16 categories of direct identifiers, and I've included those on the slide. And this data may be used or disclosed for public health, healthcare operations, or research purposes. So before disclosing limited data, the covered entity and the research must enter into a data use agreement. Oh, I'm sorry, I advanced one. There we go. So anyhow, the covered entity and a researcher must enter into a data use agreement, and you can see on the slide there's 3 points that the data use agreement needs to cover. So first, the agreement needs to identify the researcher as the recipient of the limited data set. The agreement needs to establish how the data may be used and disclosed by the recipient. And lastly, the agreement needs to provide assurances that the data will be protected. And an advantage, again, of this research involving a limited data set is that you don't need to obtain an authorization, nor do you need a waiver or an alteration of authorization requirements, even though the information is not de-identified. So here's the slide that discusses the information that can be included in a limited data set and what has to be removed. So you'll see here that it can include limited addresses, it can include all elements of dates, and it also can include unique codes or identifiers that are not listed as directly identifying the individual. And then the list here, the longer list here on the bottom, I'm not going to go through, but you'll see there are several things that still have to be removed from the information, and that's information that relates to either the individual, relatives of the individual, or household members of the individual. Okay, so moving on, I wanted to talk briefly here about repositories. We have to consider the privacy rule when creating a research database, and also for the subsequent use and disclosure of PHI that's in the database for a particular research protocol. So for some records and database research and authorization may not be needed, but at the outset when setting up a repository, an authorization is something that you need to consider, and and it needs to lay out how the information may be used for an individual. After the fact, when there's a protocol that might involve the use of information that's in a database or a repository, it's possible that an authorization isn't needed because the initial authorization covered it, or potentially you're using de-identified information or limited data sets, and then in that case you also don't need an authorization. Okay, lastly I wanted to just touch here on research with a certificate of confidentiality. Something you may or may not be familiar with. A certificate of confidentiality, or a COC, allows investigators to refuse to disclose information that could identify a research participant in certain types of legal proceedings. And it can be issued by a number of different federal agencies, and it is issued for studies that collect information that, if that information were disclosed, it could damage subjects' financial standing, employability, insurability, reputation, or have other adverse consequences. So it's pretty broad. And the privacy rule doesn't protect against forced disclosures in the same way that a COC does. So a COC offers more protection than the privacy rule. So I just wanted to draw that distinction there. Okay, now that we've covered some various considerations under the privacy rule at the outset of the study, I want to get into a discussion of some circumstances that can arise during the study. The authorization needs to describe the use and disclosures of PHI, as we discussed earlier, that will occur as part of the research. So if during the course of the research the plan for the use and disclosure of PHI changes, the authorization that was initially obtained needs to be evaluated. It's possible that it's broad enough to cover the new use or disclosure, but it might need to be revised. In some circumstances, it might be possible to get a waiver or an alteration. It really does depend on what the facts of the particular case are, and certainly it has to be run through an IRB or privacy board. So that practicability test needs to be met, and you have to provide that justification if you're submitting that type of request. Okay, moving on to retention activities and the implications under HIPAA. So assuming an individual, as I state here, has not withdrawn from the study, it's generally acceptable to contact them. When it comes to methods of contact, the first thing to consider is whether the various methods are addressed in the authorization. Now, they don't necessarily need to be, but in the event that they are not addressed, it's important to think about whether they should have, whether that method of contact is covered under the authorization. So one thing that I see sometimes is the use of a locator service to try to track down individuals. And this is something that the IRB generally wants to review and be aware of. But if the authorization indicates, as it typically does, most authorizations that I see do indicate that the sponsor or a study staff, and it'll use the terms like people they work with or their agents, are authorized to use and disclose information, I think that there's a pretty strong argument that this is probably covered under the authorization. Okay, moving on to revoking authorization, and this is the subject revoking their authorization. We all know that subjects do withdraw from studies, and I want to make a distinction here about between withdrawing from a study and revoking an authorization. It's important that we keep the difference in mind. So a research subject can revoke their authorization at any time in writing. And this is important because the privacy rule does allow a covered entity to require that the authorization be revoked in writing, which is different from consent for research. That can just be given verbally. And I want to note that although authorizations might not expire, the individual revocation is effective when the covered entity learns of the revocation. So a covered entity isn't required to retrieve information that's already been disclosed, assuming the authorization was valid, before they've learned about the revocation. So they can continue to use and disclose PHI that's already been obtained under the authorization to the extent that it's necessary to protect the integrity of the research, which in most cases it would be. Another issue that comes up during the context, during the time of the trial, sorry, is subject to access to research records. So the privacy rule guarantees individuals access to their medical records and other types of information that are within a designated record set. So if we think back to that definition, the designated record set is information that's used to make decisions about a patient. So if the research records are medically related and used to make decisions about treatment, they're part of a designated record set. The subject is entitled to have access to that information unless they've already agreed to temporary denial of access to the records during the course of the trial. And then the right of access can be suspended. So the covered entity needs to inform individuals that their access will be restored upon conclusion of the trial. And this should all be laid out in the authorization at the outset, and it usually is. Another issue that comes up during the course of the trial and also after are pregnancies, and it's something that we routinely see sponsors and researchers wanting to follow. For the pregnancy of a subject, in many cases you'd probably have anticipated wanting or needing to follow a pregnancy if it occurs, so that should be included in the authorization at the outset of the study. If you didn't anticipate that you need to follow a pregnancy, but you do once it arises, you'll need to evaluate the authorization that the subject signed and probably work with your IRB if they reviewed the authorization, or if it wasn't reviewed by the IRB, check in with the group that refused your authorizations at your organization as to whether it may be broad enough to cover that. And if a determination is made that the initial authorization didn't cover collection of the information, you would need to obtain a new authorization. For pregnancy of a partner of a subject, which is also something that we see sponsors and researchers wanting to follow, there isn't an authorization for partners. They didn't sign anything at the outset of the study. So in order to obtain information about the pregnancy, an authorization is needed. And something that we see quite often is a release of medical records that's given to these individuals. But to the extent that you're collecting this information for a research purpose, if we go back to that slide that talks about when a covered entity can use and disclose PHI for research purposes, a medical records release is not an option there. So if the information is being collected for research purposes, an authorization is needed. I do want to note that we have seen REM studies that involve pregnancies and exposure to certain products. And these studies might fall under health research or oversight exceptions under HIPAA, and in that case an authorization isn't required. All right, so last up today I want to discuss issues that come up after the study and implicate restrictions under the privacy rule. Again, we have new uses and disclosures of the PHI. If after the research has ended there are new uses and disclosures that the research wants to consider with collected data or possibly samples, again, there are various options to consider. It's possible that the original authorization was broad enough to cover the use and disclosure. It's possible you might need to obtain a new authorization. Again, we have that option of obtaining a waiver or alteration of authorization potentially. It's probably more likely after a study is ended. It's a more strong argument as far as those practicability pieces. And then the last question here is you may not need an authorization at all. It's possible potentially that some of this could be considered decedent's research depending on what you're looking at, and potentially if you've got samples or other data that it could be de-identified, or you could be working with a limited data set. Okay, moving on to contacting subjects with research results. As far as individual contact, we go back to that general concept here of communicating with an individual about their own PHI. It's not something that's restricted under the privacy rule. So if you're contacting an individual with respect to research results or something that comes up, from a HIPAA perspective, it's pretty straightforward and generally going to be allowed. In general, contact of a group is also not probably going to include PHI. So either a group of former study subjects or broader communication to a community, and I have community in quotes here because a community could be an online community of individuals. It's not necessarily a community in the traditional sense that we might have in our mind. One thing to keep in mind with the group and community contact is to be careful about identifiers relating to subjects. For example, certain geographic regions, as we discussed when we looked at the list of identifiers under HIPAA. So there's things that potentially could raise issues when you're looking at that list of identifiers. The same issues come up with locator services after the fact. And again, as I stated previously, I think a lot of times this is probably covered under the original authorization if you're talking about an agent or a person that works with the sponsor being authorized to use and disclose information. For disease and death registries, several of them require proof of an IRB approval to access the information. So submitting information to these registries to find subjects, in my interpretation, would usually be within the purpose of the research, but it's unlikely that a subject explicitly agreed to this unless it was anticipated at the outset. So there might be some scenarios where it could be argued that it really wasn't something that was authorized. So in that case, you might need to seek a waiver from a privacy board or IRB. Okay. So that concludes our walkthrough of HIPAA and the privacy rule and the considerations in the context of a research study. And I've developed a few case examples for us to go through here at the end to test our knowledge. So for this section, I'm going to read the examples, and then the questions will appear on your screen along with a selection of multiple choice answers. And you'll have the ability, once I've read the question and responses, to select the answer. So let's get started here with our first case. So a researcher wants to access the medical records of individuals who died in the flu pandemic of 1918. She makes a request for access to records housed at a Pennsylvania hospital. What should the researcher do to gain access to these records? Should she request a waiver of authorization from the hospital privacy board? Does she need to submit a request to the hospital explaining the use and disclosure of the PHI is for research on PHI of the decedents and is necessary for the research? Does she need to obtain an authorization from the living relatives of deceased individuals? Or does she have no way to access the records? There's nothing she can do. So I'll give you about 30 seconds once the polling slide pops up to provide your answers, and then we'll go through the responses. Okay, so we've got our responses in here. It looks like there's kind of a 50-50 split between response 1 and response 2, and then a few of you that thought there needed to be an authorization from the living relatives, and a couple responses that there's no way to gain access to the records. So the correct answer for this one is to submit a request to the hospital explaining the use and disclosure of the PHIs for research on the PHI of the decedents, and it's necessary for the research. And those are the two representations that are required if we think back to that slide on decedents research. If a researcher makes those representations to a covered entity, that's a way that they can have access to decedent information. So moving on to case number 2. Just a moment here while we try to advance this. Okay. So ABC sponsor is adding a new pharmacokinetic study arm to an ongoing study. The sponsor plans to run the tests with samples that have already been collected from subjects and stored. Assume subjects have provided consent for the sample to be taken and they have authorized the information relating to the sample to be used and disclosed. And what was included in the authorization here in quotes is for the purpose of conducting the study. What can the sponsor do to proceed with the testing? They can, 1, obtain a new authorization from each subject, 2, obtain a waiver of authorization from an IRB or privacy board, or 3, de-identify the samples to use them for the testing. And again, I'll give you about 30 seconds once the poll slide pops up. You can indicate your answer, and then I'll go through the responses. Okay, so we can see here that, oh, it's pretty even, all 3 options. And actually this one was a little bit of a trick because potentially all 3 options could be your answer here. So you could obtain a new authorization from all subjects, and that's your sure bet. Given that the study is ongoing, that's most likely going to be what you would be doing in this circumstance. It is potentially possible given other factors. You know, this scenario doesn't really include a lot of factual information that a waiver of authorization might be an option. And lastly, it also could be possible to, depending on what information they need along with the samples, if they're able to de-identify them and use them for the testing, that could be an option as well. Okay, so moving on to our last example here. Okay, so the authorization for a device registry indicates that female subjects who become pregnant authorize the use and disclosure of information related to their pregnancy and the outcome. Subject Jane becomes pregnant after enrolling in the registry. What does the sponsor have to do to collect information about the baby? So the first response here is that this falls under the existing authorization. Second, they must obtain a waiver of authorization from an IRB or privacy board. And lastly, they must obtain a new authorization. So again, I'll give you about 30 seconds once that poll slide pops up, and go ahead and put your responses in, and then we will go through the responses. Okay, so the majority of you indicated that this falls under the existing authorization, and about 8% thought that a new waiver of authorization is, or a waiver of authorization is needed, and then about 28% indicated that a new authorization is needed. And the last response here is actually the correct response. This doesn't fall under the existing authorization because the existing authorization is limited to information about the subject, the initial subject, Jane here, not her baby. And I specifically indicated they want to collect information about the baby, so it's not information just about the pregnancy and the birth. It goes beyond that. And as far as obtaining a waiver of authorization, it's probably pretty unlikely that you'd meet that practicability threshold, just because it's perfectly practicable to contact this one subject to obtain an authorization so that you can collect additional information about her child. So the correct response here is obtaining a new authorization. And that concludes our examples and our time. So I just want to show you I've got a few resources here. These are resources that I utilized to put this presentation together. We'll be providing the links to these on our website along with the slides so that you have access to those, and they might be helpful if you want to dig into this a little bit further. I do hope that this was a helpful overview today and brought up some points that you might not have considered previously. And I want to thank all of you for listening in, and I also want to thank Quorum for putting this on. I really appreciate the opportunity to present on the topic. So now I'm going to hand the reins over to Ari so she can cover a few additional housekeeping details. So thanks for your time today.
Thanks, Claire, for this informative webinar. We'd like to let our viewers know that if you have any additional questions, you could submit them there, and you'd like to submit them. There's an opportunity to submit questions via our survey at the end of this webinar. Alternatively, you can email your questions to clientrelations@quorumreview.com. We'll do our best to follow up individually to these questions, or we will post a Q&A on the website. And then a little more follow-up. The webinar recording, the slide deck, and the Q&A, again, will be posted on our website. We'll be emailing links out shortly so that you can know when these items are available. You can anticipate that the slide deck itself, the slides, you should have access to those within 24 hours. And then the webinar recording, we anticipate we'll have that within about 5 days. And then we do really value your opinion, so please do take this survey at the end of this webinar. Don't close your browser down once we close the survey out, or once we close the webinar out, the survey will pop up. And we really do use this time and the answers that come through to choose topics for later webinars. And then once again, I'd like to thank you for attending our webinar. We hope you found this topic information and useful. If you're interested in learning more about Quorum, please visit us at quorumreview.com, and we are now on the following social media outlets as well, so you can find us there at Facebook, Twitter, LinkedIn, and YouTube. On behalf of everyone here at Quorum, we hope you enjoy the rest of your day. Thank you.